Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome, knowledge seekers, to the deep dive. Today, we're plunging into Graham v. John Deere Co. This is a landmark Supreme Court case that really set the standard for what makes an invention truly patentable. It still shapes innovation in America today. Our goal here is to really unpack this foundational legal document and pull out the key insights.
Absolutely. It's such a critical decision because it helps define what really deserves those exclusive patent rights. Making sure it's genuine advancements getting protected, not just clever little tweaks on existing stuff.
Exactly. So we're going to unpack Graham v. John Deere itself, plus its companion cases. We'll dig right into the court's own judgment to understand this crucial non-obviousness test. Okay, let's start with the basics. What exactly are we looking at case-wise?
Right. So we're dealing with three cases that were consolidated and argued together before the U.S. Supreme Court. The main one is Graham et al. V. John Deere Co. of Kansas City et al. That's case number 11. The companion cases are Calmar Inc. v. Cook Chemical Co., which is number 37, and Colgate-Palmolive Co. v. Cook Chemical Co., number 43.
Okay, three cases rolled into one big decision. When did this happen?
They were argued on October 14, 1965. And the court handed down the judgment on February 21, 1966.
And who actually wrote the opinion for the court?
That was Mr. Justice Clark. He delivered the opinion for the majority. Interestingly, two justices, Stewart and Fortas, they didn't take part in deciding those two companion cases, numbers 37 and 43.
And I see a whole list of lawyers involved, too. Orville Gold for the petitioners in number 11, Gordon Schmidt for the respondents in 37 and 43, plus groups like the American Bar Association weighing in as amici curiae really shows this was a big deal.
Oh, definitely. High stakes.
So backing up a bit, where does the government even get the authority to issue patents in the first place?
Good question. It comes straight from the Constitution. Article 1, Section 8, Clause 8. It gives Congress the power, quote, to promote the progress of useful arts by securing for limited times to inventors the exclusive right to their discoveries. But, and this is key, the court points out this clause is both a grant of power and a limitation.
So it's not just handing out monopolies carte blanche.
Precisely. The goal is to promote advances, genuine progress in technology and the arts. Congress can't just issue patents that lock up knowledge that's already out there, or should be publicly available. So things like innovation, actual advancement, adding to the sum of useful knowledge. These are baked into the requirement. It has to be a real step forward.
That makes sense. And I remember reading Thomas Jefferson played a big role early on. He seemed a bit wary of monopolies.
He was initially, but he was instrumental in the first patent acts back in 1790 and 1793. His whole philosophy was that a patent isn't some natural right. It's an inducement, a reward for bringing forth new knowledge. And he insisted on a pretty high bar. He didn't want patents for, small details, obvious improvements, or frivolous devices. The standard needed to be high.
So how did they define that high bar back then? It seems tricky.
It was tricky. And Congress mostly left it to the courts to figure out the details beyond just novelty and utility. This led to a really important case, Hotchkiss v. Greenwood in 1851. The court there said an invention needs to show more ingenuity and skill than were possessed by an ordinary mechanic acquainted with the business.
Okay, so distinguishing real invention from just being good at your job, essentially.
Exactly. That Hotchkiss standard tried to draw that line between true inventiveness and mere mechanical skill. It was a major step in defining patentability.
Right, but it sounds like defining invention itself was still causing problems. Which leads us to the 1952 Patent Act, right? What was the big change there?
Yes, that's the next crucial piece. Despite Hotchkiss, invention was still a slippery concept. So in 1952, Congress stepped in and for the first time explicitly added a third requirement for getting a patent. That requirement is non-obviousness, and it's codified in Section 103 of the Act. So now you need a novelty, it has to be new, Section 102.
Yeah.
Utility, it has to be useful, Section 101. And non-obviousness under Section 103. And the idea was really to codify what courts like Hotchkiss were already doing, but to make it clearer, more uniform, by focusing on non-obviousness instead of the vague term invention.
Okay, Section 103. Now, I seem to recall some talk around that time, maybe before, about a flash of creative genius being required. Did the 1952 Act incorporate that idea?
Ah, good point. The court addresses that directly in Graham.
Mm.
That phrase came from an earlier case, Kuno Court in 1941. But the Graham court said, look, that was just rhetorical embellishment. It wasn't meant to set some super high standard or focus on the inventor's thought process. In fact, Section 103 was partly meant to get rid of any confusion from that phrase. It explicitly says patentability shall not be negatived by the manner in which the invention was made.
Okay, so it doesn't matter if it was a long slog or a sudden insight. The focus is on the invention itself against the prior art.
Exactly.
So the 1952 Act, with Section 103, didn't actually lower the standard for getting a patent. It just clarified it.
That's what the court concluded. The general level of innovation required stayed the same. What Section 103 did do, and what the Graham court really spelled out, was provide a more practical, objective way to test for non-obviousness. They laid out these three key factual inquiries, which we now often call the Graham factors.
The Graham factors. Okay, what are they?
All right, first, you have to determine the scope and content of the prior art, basically what was already known in the field before the invention. Second, you figure out the differences between that prior art and the patent claims you're looking at, what's actually new here. And third, you need to resolve a level of ordinary skill in the pertinent art. Who is this standard hypothetical person we're comparing against? What would they have known or been able to do?
Okay, so scope of prior art, differences, and level of ordinary skill. Get those facts straight.
And then, against that backdrop, you make the ultimate legal judgment. Would the invention, as a whole, have been obvious at the time it was made to that person of ordinary skill?
Right. But what about those other things people always bring up? Like if the invention was a huge commercial success or if it solved a problem everyone was struggling with for years, don't those count?
They can count. The court calls them secondary considerations. Things like commercial success, long-felt need, failure of others, they can be relevant. They can give light to the circumstances and act as sort of indicators, indicia of obviousness or non-obviousness. They might help show maybe it wasn't so obvious if nobody else figured it out despite trying.
Okay, so they're like supporting evidence.
Kind of, but the court was very clear. They are secondary. They can't by themselves make an invention patentable if the core technical differences compared to the prior art are obvious. They can't tip the scales if the invention itself is just a trivial variation. The main focus has to be on those three Graham factors. The ultimate question is a legal one based on those facts.
Got it. That's a really crucial distinction. So let's see how the court applied this framework to the actual cases. First, Graham v. John Deere. What was the invention?
Okay, so Graham had a patent, the 798 patent, for a clamp for vibrating shank plows. It was basically a clamp mechanism for plows used in rocky soil. The idea was to combine some old parts in a way that let the plow shank flex and absorb shock better, preventing damage. Interestingly, the lower courts couldn't agree if it was valid. The Fifth Circuit said yes, it was valid because it got an old result in a cheaper, better way. But the Eighth Circuit said no, invalid, no new result. That split is part of why SCOTUS took the case.
Okay, a flexing plow clamp. What did Graham argue made his specific clamp patentable and non-obvious?
Well, initially he talked about things like reducing wear on parts and keeping constant contact between elements. But later on, especially in court, the big argument became this idea of free flexing. He argued his design was unique because it allowed the entire shank from top to bottom to flex backwards when it hit a rock.
Free flexing.
Okay. And what did John Deere say in response? Why did they think it was obvious? John Deere basically said, hold on, look at the prior art. They pointed to Graham's own earlier patent, the 811 patent, and crucially another device called the Glencoe clamp. Now, the Glencoe clamp hadn't even been considered by the patent examiner who approved Graham's 798 patent.
Oh, that's significant.
Huge. Deere argued the Glencoe clamp had basically all the same mechanical elements as Graham's 798 patent. It worked the same way, even though some parts were inverted. They said any differences were just minor design choices, well within what an ordinary skilled person in plow design could figure out. And the court also noted that this whole free flexing argument seemed like an afterthought. It wasn't really mentioned in the original patent application.
So faced with all that, what did the Supreme Court decide on the Graham patent?
The Supreme Court sided with John Deere in the Eighth Circuit. They found the 798 patent invalid. Their reasoning followed the Graham factors. They looked at the prior art, including Glencoe. They saw the differences were minor. They concluded that even if Graham's specific arrangement wasn't exactly shown before, the idea of, say, inverting the shank and hinge plate like Glencoe did, or achieving that flex in other obvious ways, would have been readily apparent to a person skilled in the art. Simply moving a wear point around wasn't inventive. The Glencoe device, operating identically, made Graham's claims obvious.
Okay, so the plow clamp patent was struck down. Now, what about the other cases involving Cook Chemical? What was their invention?
Right, the Calmar and Colgate-Palmolive cases. These dealt with a patent assigned to Cook Chemical, invented by Baxter Scoggin, Jr. It was for a plastic finger sprayer, the kind you see on household cleaner bottles, but designed specifically to be shipped with the liquid inside. It combined the pump sprayer, a cap for the container, and a special overcap. When you screwed down the overcap, it sealed the sprayer for shipping and prevented leaks. It was designed for automated assembly lines and was called a shipper sprayer.
That actually sounds pretty useful. And Cook Chemical apparently argued it was a big deal, right? A novel combination, solved a long-felt need, huge commercial success. The lower courts bought it.
They did. Those arguments were strong on the surface. It was commercially successful. But again, the Supreme Court dug deeper, and this is where looking at the patent's history became critical. They examined the file wrapper.
The file wrapper, that's the back and forth with the patent office.
Exactly, the whole prosecution history. And what it showed was that Scoggin's initial patent claims were quite broad, and they were rejected by the examiner. To get the patent allowed, Scoggin had to significantly narrow his claims. He ended up focusing almost entirely on two very specific sealing features. One was using a particular kind of seal, like a rib seal inside the cap. The other was that the bottom edge of the overcap didn't touch the container cap below it. There was a specific little space there.
So the patent he actually got was much narrower than what he started with, focused on just those two details, the rib seal and the space.
Precisely. So the question became, were those specific features obvious in light of the prior art?
Okay, so what did the prior art show about those specific seal details?
Well, there were some relevant patents the examiner did consider, like one called Loose, similar sprayer, different seal, and Melon, seal, but used a gasket. But the real kicker was a patent by Livingston. The examiner hadn't cited this one. Livingston showed a closure device, and critically, it had a very similar sealing mechanism, kind of a tongue and groove thing, no gasket needed. And it had the exact same kind of space between the overcap and the container cap that Scoggin was claiming.
Wow. Even though Livingston wasn't claiming that space as his invention, it was disclosed there.
It was disclosed, publicly available in the patent document from 1953 before Scoggin's invention date.
Now, wasn't Livingston for something different, like pouring spouts, not insecticide sprayers? Did the court think that mattered?
That's a key point. The court said Livingston was pertinent prior art. Their reasoning was that the fundamental problem Scoggin was solving was a mechanical closure problem, how to seal a container effectively for shipping. It wasn't specifically an insecticide problem. So prior art for closure devices on other types of liquid containers, like pouring spouts, was considered relevant to someone skilled in designing closures.
That really broadens the scope of what counts as prior art an inventor needs to be aware of.
It does. You need to look at related fields solving similar mechanical problems.
So considering the narrow claims and the Livingston patent, what was the court's final decision on the Cook Chemical Scoggin patent?
The court reversed the lower courts. They found the Scoggin patent invalid for obviousness. They basically said the differences Scoggin relied on, that specific rib seal in the space, were exceedingly small and quite non-technical, end quote. Those features were clearly suggested or even shown by the prior art, especially Livingston. The space was a necessary result of the design, not some inventive leap, and the rib seal was just an analogous way to achieve what Livingston did with tongue and groove. And again, those strong secondary considerations like commercial success couldn't make up for the fact that the core technical differences were obvious.
Invalidating both patents based on this non-obviousness test. So pulling it all together, what's the big takeaway? What's the lasting impact of Graham v. John Deere today?
It's truly a cornerstone of modern patent law. Its biggest impact is establishing those Graham factors as the definitive framework for analyzing non-obviousness under Section 103. It brought much-needed structure and clarity to what could be a very subjective determination. It also firmly stated that Section 103 codified the existing high standard for patentability. It didn't lower it. Patents are meant for genuine, non-obvious innovations.
And it seems like it put the patent office on notice too, didn't it?
Absolutely. The court really emphasized the primary responsibility of the patent office. They stress the need for the PTO to rigorously apply this non-obviousness standard to prevent the system from getting clogged up with patents on trivial things. It's about filtering out those insignificant variations and innovations of a commonplace sort. The court used that memorable line, "He who seeks to build a better mousetrap today has a long path to tread before reaching the patent office."
That really sums it up. It's got to be genuinely better and non-obvious, not just a slight tweak. What a fascinating deep dive into such a foundational case. It really shows that tension between rewarding inventors and keeping basic building blocks free for everyone.
I think the most important key takeaway here is really the framework itself. The Graham factors give us this clear analytical process. Look at the prior art, see the differences, consider the skilled person to determine if an invention is truly a non-obvious step forward. It ensures patents are rewards for real contributions to the useful arts, not just clever rearrangements of what we already know. That structure is its enduring legacy.
A powerful legacy indeed. And it leaves us with a question to ponder, doesn't it? In our world of incredibly fast innovation and constant iteration, how does that spirit of Graham, that demand for non-obviousness, continue to challenge inventors? How do we ensure we're truly promoting the progress of useful arts in ways that genuinely move the needle and not just refining the familiar? Something to think about until our next deep dive.